the good job. I get to do the intro, the sort of technical overview to provide the basis on which the speakers that follow me will build. As you can see, we're looking this morning at critical success factors, and good, the button worked, and the changing face of intellectual property. A lot of this we may worry that we've heard it all before. Some of what I say this morning you may have, but for the sake of everyone in the room, we'll make sure we just cover off on that so that you've all got the basics of intellectual property tucked away, and that we can then build on that. Now, why intellectual property matters? Why are we all worrying about this? Well, the interesting thing is that capital markets and investment analysts are increasingly focusing on what might be called intellectual assets. And as you can see there, and these figures are albeit 3 or 4 years old, but they still ring true, and interestingly, they still certainly ring true post-GFC. Greater than 75% of value of Dow companies, and that's not just the high-tech ones, are attributed to intangibles. And if we look back over history, that's up 50%, up from around 50% in 1992. And the other thing is there's simply more intellectual property around. As we'll see in a moment, that's a very broad definition of intellectual property, but looking just at patents filed per year, less than 100,000 patents filed per year back in 1990, up to over 400,000 filed per year in 2006. For international, or what are called patent cooperation treaty patent applications, around 20,000 back in 1990, over 150,000 just in 2006, and those numbers have continued to trend upward since 2006, as I say, despite GFC. Okay, this is the brief overview of intellectual property. Patents, what do? They protect the way something operates, the way it functions. It might be a widget, it might be a process. It could even, in certain countries, be a business method. So quite broad range of things that can be protected by way of a patent. Trademarks, David Stewart's going to talk to us a little bit more about trademarks and certain issues related with them a little bit later, but they are a badge of origin. How do you know the services that you're buying are going to come from someone that you trust? Well, you know the KPMG name, so you know that you can trust the provider of those services. It's indicating to you what is the trade origin of those goods or services. Domain names, similar thing. David again will talk to us a bit more about those. Something, I mean, having been in the patent attorney profession for 20 plus years now, heaven forbid, something I noticed back in the late 90s as the whole internet thing really took off is the emerging importance at that time of domain names and the increasing awareness that suddenly became apparent of intellectual property matters, just coming out of directly the fact that people were acquiring domain names that they were going to misuse often, and that increased in the public's eye the importance of intellectual property. Registered designs, they protect the way something looks, not how it functions. That's dealt with by patents. So registered designs, how it looks. A stapler might be protected by way of a patent in terms of the mechanism of action, but the way that particular stapler looks, it can be protected by a registered design. Circuit layouts, obviously layout of circuit boards. Copyright, that is not so much a registered right like the earlier rights that I've just mentioned. Copyright exists automatically. I'll let Dave perhaps explain a little bit more about that. Trade secrets and know-how, they are a lot of the information that comes around these other things. If someone licenses use of a product, often they will also be licensing the know-how that goes with operating that product. And confidential information. What do you know as a result of having the job that you have and working for the person that you are working for? That is often confidential information. Can you just walk away with customer lists? Not necessarily. Confidential information. It's a tricky area, but one, if you're in that sort of a situation, well worth taking advice on. Okay, this is a slide we like to use just to demonstrate graphically how a number of these things relate to a product that you might be aware of. Something that stands out immediately is how old this slide is. It should be a smartphone, but it's not. I don't think that looks like a Nokia, 6100 or something like that. As I said before, and can people hear me if I walk away from this? Good. Patents protect the way something works. So there'll be a lot of software and a lot of hardware in the phone that is protected by way of a patent. Registered designs, that's the visual appearance of that particular phone. Copyright, there's a lot of copyright associated with software as well. The code often attracts copyright protection. Circuit layout rights will reside in there'll be actually a printed circuit board in there somewhere to which circuit layout rights relate. And obviously the trademark Nokia, if it's a Nokia phone, that's obviously the house mark, but there may well be sub-brands that exist underneath that house brand name. Something that's not standing out on this, this slide is the fact that there are also, and I had intended to mention it on the previous slide, things that people are now calling intellectual assets, so slightly different from intellectual property. Intellectual assets can be looked at as slightly broader than the IP definition that I've provided so far, and that is a term, if you Google it to misuse their trademark, is often seen as bringing in issues relating to people. So a lot of HR issues. Are the people selling the brand, so to speak? And Joe will talk to us a lot about that a little bit later. Okay, how do we deal with the protection that we obtain? And this is part of where we get into the, what else is changing aspect of what we're talking about this morning. Look, people have looked at a lot of these rights traditionally as a way to simply exclude people from a particular area of technology. I have a patent over this widget, therefore you can't make that same widget, so if anybody wants to buy that widget, they have to buy it from me. Companies are now increasingly aware of the benefits that come with licensing, perhaps having a more open view as to how people may access that product. And we see, and I see this personally in my practice in the mineral processing area, a lot where we're seeing cross-licensing and technology sharing opportunities that come out of people obtaining patent protection. So company A has a particular technology patented that relates to processing a particular ore type. Another company comes along, they have a similar ore type, they want to be able to process it in the best way. How do they do that? Do they flagrantly infringe company A's protection? Well, they don't have to if company A perhaps has an open view as to how they're going to generate revenue streams. Maybe they wish to license that technology to the new entrant, because it may be that they can make more money out of having their patent by doing it that way than by simply excluding the other party and perhaps wearing costs associated with having to enforce that patent. So we're getting more and more creative thinking around how people deal with intellectual property. We're seeing that a lot in the IT companies. If you can't avoid reading about Apple and Microsoft and Nortel patent portfolio being sold for billions of dollars and so on. So these companies, they acquire these bundles of rights and then they madly license everything to each other. Occasionally they sue each other, but often those people are also involved in licensing arrangements. So there is quite an open view to how these things are done. And it's not simply Apple is a closed shop, they keep everything tight. Microsoft is open, everybody can license that platform. It's interesting, you look at those companies, they each have huge patent portfolios and they're each involved in a multitude of licensing arrangements as to how they then ultimately put this product in front of you in the long run. On Christmas holidays, I'd been given the Steve Jobs autobiography, and I was never an Apple person. So, you know, I remember growing up back in the 80s. You know, you tended to either be an Apple person or a Windows person, and that continued largely through the 90s. Became particularly apparent towards the late 90s when Steve Jobs reappeared at Apple. But I never really bought into all of that. I tended to be probably more of a Microsoft person. But reading this this biography, apart from all the stuff around the fact that Steve Jobs apparently wasn't a very nice man, he was very creative. This is a really, I think, at one level obvious, but it's worth saying again. And this is a quote from Steve Jobs. "From the earliest days at Apple, I realised that we thrived when we created intellectual property. If people copied or stole our software, we'd be out of business. If it weren't protected, there'd be no incentive for us to make new software or product designs. If protection of intellectual property begins to disappear, creative companies will disappear or never get started. But there's a simpler reason: it's wrong to steal." This is all a bit Alice in Wonderland perhaps at the end. "It hurts other people and it hurts your character." Okay, that may be so, but the earlier comments are very true. As we've already seen, a lot of the value of these companies, a significant proportion of the value of these companies is down to their intellectual property and their intellectual assets. And if they didn't have it and they didn't actively seek to obtain it, then arguably they would have very little in the end. Now, Steve Jobs, he was a tweaker and a borrower. He didn't actually come to any of these things first. Okay, the mouse was actually Xerox's idea. He acquired it and made it work, made it usable. The icons that we're all familiar with, the graphical user interface, again, that was Xerox's. They made it work. The iPod, there were music players, MP3 players before Apple got into it. They made one that people actually wanted to use. The iPhone, again, they were late to the smartphone market, but again, they make one that people actually want to use. And the iPad, there were tablets before. Steve Jobs was obsessed with this idea of not having a stylus to write on your personal digital assistant or whatever. They put the effort and the time into making that work. And actually what that involved was they acquired a company that had the technology and they had it protected. They went and bought that company, so they brought it in-house. This isn't restricted to IT. As said before, I work in mineral processing a lot of the time. A lot of the processes that we are patenting for people at the moment are tweaks on technology first developed in the middle of last century. Just keeps getting developed, keeps getting better. And people are getting protection on that so that they can often, if they choose to, just exclude people from that area. But more often these days we're seeing that people are being constructive about how they then deal with that intellectual property and entering into technology sharing arrangements. It's a great way for that company to get something that it perhaps wants from their competitor. Thank you.